Hello, welcome to Shorthand Hangover. Get ready. Start. I have perused arguments of learned counsel for revisionist, the case file and order under question. After going by the arguments of both sides, the learned counsels, and the perusal of the case file, summarily, the order dated the 30th of April 2018, passed by Additional Session Judge, Court Number 1, Muzaffarnagar, seems erroneous. Therefore, this criminal revision is hereby accepted, and Session Revision Number 508 of 2015, State Versus Jagpal, passed by Additional Session Judge, Court Number 1, Muzaffarnagar, vide order dated the 30th of January 2018, is hereby quashed. It is hereby directed that, without being influenced by the merits of any observation made in this order, after allowing sufficient opportunity to the parties and after complete perusal of the case file, appropriate order be passed in the matter within 2 months. The office is hereby directed to ensure of sending a copy of this order and the record of the case to the court concerned without any delay. The scope and ambit of Section 319 of the Code has been well settled by the Constitution Bench of this Court in Hardeep Singh versus State of Punjab and others, and paras 105 and 106, which are relevant for the purpose, are reproduced hereunder. Power under Section 319 CRPC is a discretionary and an extraordinary power. It is to be exercised sparingly and only in those cases where the circumstances of the case so warrant. It is not to be exercised because the magistrate or the sessions judge is of the opinion that some other person may also be guilty of committing that offense. Only where strong and cogent evidence occurs against a person from the evidence led before the court that such power should be exercised, and not in a casual and cavalier manner. Thus, we hold that though only a prima facie case is to be established from the evidence led before the court, not necessarily tested on the anvil of cross-examination, it requires much stronger evidence than mere probability of his complicity. The test that has to be applied is one which is more than prima facie case as exercised at the time of framing of charge, but short of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. In the absence of such satisfaction, the court should refrain from exercising power under Section 319 CRPC. In Section 319 CRPC, the purpose of providing, if it appears from the evidence that any person, not being the accused, has committed any offense, is clear from the words for which such person could be tried together with the accused. The words used are not for which such person could be convicted. There is therefore no scope for the court acting under Section 319 CRPC to form any opinion as to the guilt of the accused. The Constitution Bench has given a caution that power under Section 319 of the Code is a discretionary and extraordinary power which should be exercised sparingly and only in those cases where the circumstances of the case so warrant, and the crucial test, as noticed above, has to be applied is one which is more than prima facie case as exercised at the time of framing of charge, but short of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. Over. Thank you.